That such a blunt response to the breakdown in law and order would be tantamount to sacrificing the right of the accused person in order to secure peace and security for the rest of society, not be invoked as a reason for the scrutiny for the security apparatus and the state to refuse to undertake their foremost duty to protect all citizens and maintain.
Thank you very much, and I'm sure the Lord will smile upon you. I would like to see you up.
Why should the police arrest a citizen if they do not even have a provisional view of the offense that the citizen has committed? It will seem repugnant to the ethos of the Constitution, of the constitutional justification of the exercise of power and authority in which our Constitution is steeped in, to encourage such practice, even if not categorically unconstitutional textually. In many cases, such police action would be, in context and effect, unconstitutional. This would be the case where the police conduct reveals a pattern or desire to overreach or to deploy the criminal justice system in a manner which unnecessarily diminishes rather than aggrandizes personal liberty or autonomy of arrest. Even while accepting that the text of Article 49(1)(f) may in certain circumstances and contexts comprehend a situation where a person is presented before a court without being formally charged and is thereby informed of the reasons for his continued detention through the state's application to have him so held, the state must satisfy a double test. And this is the test that the court went out to lay with good faith, and that the continued detention of the individual without a charge being preferred, whether provisional or otherwise, is inevitable due to existing exceptional circumstances. Second, the state must demonstrate that the continued detention of the individual without charge is the least restrictive action it can take in balancing the quadruple interest present in a potential criminal trial. That is, the rights of the arrested individual, the public interest, order and security, the needs to preserve the integrity of the administration of justice, and the interest of the victims where appropriate. By virtue of Articles 21 of Article 1 and 259 of the Constitution, the court must act to aggrandize, not to diminish personal liberties of arrested individuals in line with the three interests. Differently put, the state must demonstrate that there are compelling reasons to deny pre-charge bail while balancing all factors within the complex permutation presented by these quadruple interests without rareifying or essentializing any. End of quote. In the present scenario, it is not in question that the respondents were arrested on the 5th of December 2025, and to date, that is the 11th of December 2025, they have been in custody of the police for a total of 7 days. It is expected that during the intervening period, the investigators have taken all necessary steps to safeguard the evidence of the witnesses whom they consider to be susceptible to interference. Having so found, the upshot is that although the applicants have demonstrated compelling reasons to detain the respondents in custody so as to safeguard the integrity of the investigations, it is the opinion of this court that the period which the respondents have been in custody, that is from the 5th of December to date, is sufficient time for the investigators to take necessary steps in order to safeguard the investigations. And as such, the court finds no justification for any further detention of the respondents. Consequently, the respondents may be set at liberty forthwith unless they are lawfully held in custody. Those are the orders of the court.
Jina naitwa Koresha Gabo. Niko na furaha, nimeona kuja kuona mtu yangu na vile jaji rule yake iko sawa. Sasa niko na furaha yangu. Mimi ile mkosa ameshikiwa, sasa serikali tu ndio wanajua ameshikia nini, lakini kwenye mimi najua kwa roho yangu, brada yangu si mtu anafanya mistake.
Naitwa Boniface Heshima na nina furaha sana siku ya leo. Tulikuja hapa on Monday lakini hatukuelewa vile walikuwa wameamua, maana most of them walikuwa cases hazijakuwa filed na walikuwa pia hawajashtakiwa. So tukarudi, lakini leo tumerudi na tunashukuru sana vile Magistrate amesema. Yaani walivyoachiliwa nimeshukuru sana. Actually hawakuweza kuleta hizo investigation, na hata whoever nilikuwa nimekuja kushuhudia kesi yake hapa alikuwa ni shemeji yangu, na pia yeye mwenyewe binafsi alikuwa anasema hajafanya kitu. So in short, mimi naona kulikuwa tu yani wamepatiwa muda, lakini kwa sababu hawakuleta pia vile koti imefanya, this is the Kenya we want. And personally, I truly appreciate and I'm so happy.
Ruling is that the outcome is what we were looking for, that they should be released. In our view, there was no compelling reason to arrest people from different locations, different departments, and allege that they have committed offenses which are not disclosed, nor even there was no hint of the nature of evidence or they may have regarding the offenses that they stated that they want to investigate.